Okay, we're going to go on the record on cause number DC 232476, Adams v. Smith. Counsel, make your appearances.
Johnny Workman and Blake Bailey for defendants.
Sharon Campbell for the plaintiff.
All right, you may proceed.
Good afternoon, Your Honor. We're here today on defendant's traditional and no evidence motion for summary judgment. If you'll recall, we previously filed a 91A in this case, and plaintiff has repled a few times, and we were ordered to mediate, which we did attempt before today's hearing, which was unsuccessful, unfortunately. Since then, plaintiff has filed her third amended petition, which was filed January 4th, and then this MSJ was filed on February 1st. Since the filing of this motion for summary judgment, plaintiff has amended her petition twice more, now up to the fifth amended petition, which was filed on April 29th. But when plaintiff amended recently with her fifth amended petition, she did drop two of her claims, which were included in this motion for summary judgment, which are now moot. Those two claims, which we don't need to address anymore today, are the discriminatory housing practices and DTPA claims. Also, we had a call with plaintiff's counsel last Friday, and it was discussed that she's added headers to a couple of these claims in the fifth amended petition, but the substance was still there in the third amended petition, which is what this motion for summary judgment was based on. And we all kind of agreed that there was no surprise to any of the parties on what these claims are, and that the titles of these claims that have now been added as headers in the fifth amended petition didn't change the substance. So we believe that we can proceed with all of the claims that we filed for under our motion for summary judgment today, including the ones that she added headers to in the fifth amended. So just to give you a kind of a recap on the background of this case, plaintiff is a tenant of defendants under a lease agreement. She's been receiving Section 8 rental assistance from the Dallas Housing Authority, who pays the majority of her rent, but she fell behind in November of 2019. And after defendants sent her a notice of lease termination and demand for payment of past due rent, she began making complaints about the repairs to the property. And you'll see today that the evidence shows that no written repair requests were made by plaintiff to defendants until after she was already delinquent in her rent and after defendants had already demanded payment from her. And then 2 days after that, after defendants had sent a notice of lease termination, plaintiff filed this lawsuit. After that, defendants tried to work with Ms. Adams to get caught up on rent, but she just couldn't get there. She's still severely delinquent in rent. And so then defendants filed an eviction action in April of 2023 and was awarded possession of the property by Dallas County Court at Law Number 3, Judge Montgomery, on January 19th, a couple of months ago, January 19th, 2024. And so today, defendants are seeking summary judgment on plaintiff's claims for breach of contract, promissory estoppel, specific performance, gross negligence, landlord retaliation, failure to make repairs, fraudulent inducement, and attorney's fees. Starting first with Ms. Adams' breach of contract. Defendants filed for traditional and no evidence motion for summary judgment on her breach of contract claim. For a breach of contract claim, you have to first have a valid contract. She has to have performed or tendered performance. There has to be a breach.
No, I'm sorry to interrupt. I cannot hear Ms. Workman.
I'm sorry. Is that better? Can you hear me?
I can hear you fine. Ms. Campbell, can you hear me?
I can't hear anybody. All of a sudden, it was I was just.
Can you hear us now? Can you hear us now? Rhonda, can you hear me?
Yes, Judge.
I can hear you also.
Check your sound.
I can't hear you, Your Honor. I see you're speaking, but I can't hear you. I do.
Look at the chat.
I checked that and it's fine. I was hearing her perfectly until it stopped. And I checked wireless. My computer wireless is on. I have wireless, so it's not a connection. My sound, it's up to the highest, with the bars all the way across.
Do you want her to call in or something so she can hear, or?
Yeah, I guess.
Do I log off and try to log back on? Or I can call. Okay, I can call.
That's strange. We can all hear you.
Hi, can you hear me?
Yes. This is Sharon Campbell.
Okay.
I was hearing her going along and then it just stopped. I had checked my sound and it's on the highest, the bars all the way across. My wireless, I have wireless. It's showing me in good standing there.
Rhonda, can you tell her if this works for y'all? Why don't we reschedule this the next Monday and we can do a hybrid hearing? Miss
I
South.
just now can hear. I can just now hear you, Your Honor. I don't know. Ms. Workman, can you try and see if I can hear you again?
Sure. Can you hear me?
Yes, I can hear you now. I don't know what happened.
Okay. All right, let's keep going.
All right. Thank you.
Okay. All right. Are we all good? Are we all clear to proceed? Ms. Campbell, can you still hear me?
She hung up. I don't think she understood. Call me back.
Can you hear us, Miss Campbell?
She hung up. She's gonna have to stay on the phone in order to hear you guys. Hi, I believe you hung up. You have to stay on the phone so you can hear them, because you can only hear them because I have them on the phone.
Oh, okay. Okay. All right. Fine.
So what I was going to suggest that we just reschedule this to next Monday at 10 and we can do a hybrid hearing. You guys can Zoom in, and then Miss Campbell, she's had technical issues in other cases I've had with her. And so that would be a perfect time for me to be able to do this hybrid if you guys could do it next Monday at 10.
I'm sorry, Your Honor, but I can't do it next Monday. I've got mediation in the morning and the afternoon.
Okay. All right, then we'll just do it this way, I guess. Go ahead.
Okay. Thank you, Your Honor. Picking back up, starting with Adams, the plaintiff's breach of contract claim. Defendants filed for traditional and no evidence on her breach of contract claim. I'm sorry, I'm getting a lot of feedback. Ms. Campbell, can you mute your?
I had it on speakerphone. That doesn't work, so I'm sorry.
Oh, okay. Okay. Okay, so the elements for breach of contract claim, you've got to have a valid contract. Plaintiff had to have performed or tendered performance under that contract, and there has to be a breach of the contract and damages as a result of that breach. plaintiff's breach of contract claims based on her allegation that at some point the lease agreement that she had entered into with defendants turned into a contract for sale, and that she had an oral contract to purchase the real property at issue in this case for $240,000. However, this is false, and plaintiff has supplied no evidence to support that allegation. There has never been any agreement to sell the real property to plaintiff for $240,000, as she alleges. There were early on discussions about potential sale to her of the property, but they never agreed on the price, never agreed on the terms, and defendants never agreed to sell her the property for $240,000. First, under Section 26.01 of the Texas Business and Commerce Code, which is the statute of frauds, an oral contract for the sale of real property is unenforceable. And the only documentation that plaintiff has supplied in support of this argument is an unsigned contract with terms that defendants never agreed to. If you look at the contract that she provided, she admits in her response and in her Fifth Amended petition that it was just a proposed contract. It is unsigned. So there is no written contract at all for sale of this real property like she alleges. And instead, she relies on a promissory estoppel claim for an oral contract to sell the real property. However, the JP Court and County Court at Law on Appeal have exclusive jurisdiction on the issue of possession of real property. And on January 19th at the eviction trial, she made the same argument to the county court that she's making here, that she had an alleged contract to purchase this property. The county court in the eviction case held that Ms. Adams, in fact, did not have a contract to purchase the property, and that defendants had properly terminated the lease and was entitled to possession of the property. And you'll see that we've attached as Exhibit B to defendants' motion for summary judgment, the final judgment that was entered in the county court case awarding possession to defendants for the real property. There's also no evidence that Ms. Adams performed any part of the alleged contract. She alleges that she tendered payments to defendants, which she's calling partial down payments for purchase of the property. But in reality, the payments made by Adams are rent pursuant to the lease agreement. The lease agreement you'll find is attached to defendant's motion for summary judgment as Exhibit A1. And all the payments made by Adams were rent pursuant to that lease agreement. To argue otherwise would necessarily require that Ms. Adams admit to defrauding the Dallas Housing Authority, who has been making the majority of plaintiffs' rent payments on her behalf, not down payments to purchase the property. You'll see as Exhibit A2 to defendant's motion for summary judgment, there's a notice from the Section 8 of the Dallas Housing Authority where it shows what portion of the rent the Dallas Housing Authority has been paying and what portion that she is required to pay. And these are clearly rent payments, not payments for any kind of purchase of the property. Additionally, Ms. Adams is judicially stopped from claiming that she could perform under some kind of contract or agreement. She couldn't have tendered a down payment for the property because she's already sworn to this court and the county court, actually, by way of her affidavit of inability to pay, that she can't afford the court costs for this lawsuit. That affidavit in Ms. Adams' position was accepted and adopted by this court, so her breach of contract claim must necessarily be barred by judicial estoppel as well. She alleges that she has somehow secured financing for $300,000 to purchase the property, but that letter that she's supplied as evidence of being able to have this financing is conditional and contrary to the affidavit that she's already provided to this court. So we are moving for traditional and no evidence motion for summary judgment on her breach of contract claim because there can't be a breach of damages arising from a contract that doesn't exist. There's no written contract. There is no oral contract. There is no agreement between the parties other than the lease agreement that we've already supplied as Exhibit A1 to the motion. So there's no evidence to support any of the elements for a breach of contract. Moving on to her promissory estoppel claim. Because no actual contract, no written contract for the purchase of the property exists, she asserts a promissory estoppel claim. She attempts to argue that it's a new claim added in the Fifth Amendment petition, but Like I've already stated, we kind of agreed on Friday that that was substance that was already in the third amended petition, which is what our motion was based on. It was also addressed by paragraph 60 of our motion for summary judgment, so there's no surprise to the parties on this. So according to Texas law, a purchaser of land may enforce an oral contract by showing payment of the consideration, possession of the property, and valuable improvements or other facts that would make the transaction a fraud on the purchaser if the contract remains unenforceable. It has to be virtual fraud, and that's the only way to get around the statute of frauds with an oral contract. However, Ms. Adams has presented no evidence to support that there was any kind of agreement between the parties. There was no agreement or contract of any kind ever entered into between plaintiff and defendants for the sale of this real property for $240,000. Again, it's already been decided by the county court that no contract for sale of the property existed, and she's presented no evidence of any such agreement between the parties. Further, she alleges that a misrepresentation was made and that she relied on that misrepresentation to her detriment. However, there's no evidence that any misrepresentation has ever been made by defendants. They never agreed to sell her the property for $240,000. For the same reasons that have already been stated, there's no payment of consideration that's ever been tendered to defendants for purchase of the property. And she doesn't even allege that any payments have been made as down payments for purchase of the property. In her response, all that's alleged is that she paid rent and she was severely delinquent in rent. And the only payments that have been made by Ms. Adams were pursuant to the lease contract as Exhibit A1. Plaintiff's claim for promissory estoppel must also be barred by judicial estoppel based on her affidavit to the court alleging her pauper status. And it would mean that if she makes this claim, that she's been defrauding Dallas Housing Authority since they've been making the majority of her rent payments.
I think you've already made this argument.
Yes. It's sort of the same, kind of goes along with the breach of contract argument.
Okay.
It's the same sort of grounds there. Okay. So defendants are entitled to summary judgment on her breach of contract claim and the promissory estoppel claim because no valid contract or agreement exists for the sale of this real property as she alleges. So there can't be a breach or any damages caused by any said breach. As far as specific performance goes, because her claim for breach of contract fails and promissory estoppel fails, there can be no claim for specific performance. So we allege that there's no evidence to support a claim for specific performance since her breach of contract and promissory estoppel claims fail as well. Moving on to landlord retaliation. So plaintiff asserts that defendants have violated section 92.331 of the Texas Property Code and retaliated against her by serving her with a notice to vacate after she began complaining about the property and making repair requests. But the very next section of the Texas Property Code, section 92.332, very clearly explains that an eviction or lease termination based on the tenant's delinquency in rent does not constitute retaliation. At the time that we served her with a demand for payment and the notice to vacate, the notice of lease termination, she was severely delinquent in rent already. At that point, as of November 2019, she was delinquent in rent, which is shown by the ledger that's attached to the motion for summary judgment as Exhibit A3. And she acknowledges her delinquency. Plaintiff acknowledges that she was behind in rent in her petition, in her response, and in a couple of the exhibits that she's got attached to her response. The lease had long expired when the defendants decided to terminate the lease based on her continual failure to pay rent on time and the deterioration of the property. In January, so her rent arrearage began, she fell behind beginning in November 2019. In January 2023, defendants sent a demand for payment of delinquent rent, and that is attached to plaintiff's response as Exhibit 23. And then between sometime after receiving our demand for payment, Ms. Adams sent a letter requesting that repairs be made and wanting a payment arrangement to catch up on delinquent rent. So there, as of January 21, at least January 21, 2023, she acknowledges that she was severely delinquent in rent. After that, defendant sent a lease termination notice on February 20th, 2023, which they have every right to do because the lease was long expired. They gave her proper notice, which was determined by the county court of law already. You'll see that in Exhibit A4. And then just a couple of days later, she filed this lawsuit. After that, in April 2023 is when the eviction case was initiated. So there can be no retaliation if at the time she makes repair requests and we send a notice to vacate, she's delinquent in rent, which she was. She was severely delinquent in rent as of the time that we sent a demand for payment and the notice of lease termination and the notice to vacate. So as a matter of law, there can be no retaliation under the Texas Property Code 92.332.
All right, we're really kind of way past time, so let me hear from Ms. Campbell. Ms. Campbell, are you there?
I think she's muted.
Okay, ma'am, go ahead and speak.
Okay, I want to address what Miss take off the speaker. I wanted to address what Ms. Workman said about the conversation that we had on Friday. And I think she's broadened what I understood I was suggesting. We had the Fifth Amended petition added in the failure to repair. That had not been previously put in there, though it had all been addressed and we'd all talked around it. And so that's what I was addressing with Ms. Workman, that although it had not been specifically pled, all the parties were on the same page with regard to failure to repair. That does not address the promissory estoppel and specific performance. That was pled in the previous amendment, and that was pled after the motion for summary judgment was filed. So our position is that is not addressed by the summary judgment. There is nothing in there's motion that addresses promissory estoppel or specific performance. So whatever happens here today or as a result of this hearing, I don't believe it could be a full and final summary judgment because those are two causes of action had not been addressed by this motion. And I think that the promissory estoppel is what is an exception, operates as an exception to the statute of frauds, and that's what keeps the breach of contract claim alive, and that's what she's claiming with regard to this sale. And the proposed contract was sent in response to what Ms. Adams believed to be the offer that had made. Where would she come out of that, her own, just come out of her own making it up that there was this promise? Why would she prepare this contract when there had not been any discussions of that? And so I think that's a factual dispute. And the fact that
is your client claiming there's an oral contract for sale, or Ms. Campbell, is she claiming there's an oral contract for sale? Or what exactly is her argument?
I'm not hearing.
You can't hear me, Ms. Campbell?
Our understanding, Your Honor, is that she is alleging an oral contract for the purchase of the property. Yes.
Yeah.
That's our understanding.
Okay.
Can y'all not hear me?
We can hear you.
Fine. Ms. Campbell, can you hear me? Rhonda, are you
She's hung up. She's got to call me back. I think she disconnected the call. Ms. Campbell?
Yes.
Okay.
All right. All I did was take the speaker phone off, and all of a sudden I was disconnected. So I apologize for these problems, Your Honor.
This just isn't working, guys. So you can't do next Monday. Could you do this Friday? No, Friday I'm not going to work because I'm going to be in trial. And you said you're not available next Monday. How about not this Friday, but next Friday? Can you
The
ask?
17th? Yes, I could do the 17th.
That's okay with us, Your Honor.
All right, Ron, to reset this to the 17th at 10 o'clock.
Okay.
And counsel, can you go ahead and prepare for me a notebook that has both sides briefing in it with highlighted cases for both sides? Work with Ms. Campbell on it. Also include there the most recent petition and I guess, yeah, the most recent petition, the Fifth Amendment petition in it. And then and you can show up. Ms. Campbell, you have to be in person. I don't know what's
That's
to do.
fine. I don't have any, but I'm happy to be in person.
And the other side, you can be in person or remote. It doesn't matter.
We'll come down, Your Honor.
We prefer in person too.
It's up to y'all. Okay, so we'll do that not this Friday, but next Friday. And if you could just make sure to bring with you that notebook, counsel.
Yes.
Did you get what I wanted in it?
Yes, I believe I did.
And then also a checklist order that has each of the causes of actions that are asserted and whether or not I'm going to grant or deny. So something I can just checklist.
Got it.
For each one.
Got it. I can do that. What time that Friday?
10 o'clock.
10 o'clock. Okay.
So Rhonda, not this Friday, but next Friday.
17th.
And Ms. Campbell, you've got to get a tech person or something. Because as you always seem to have.
But I do Zoom all the time, and I don't know why it is just in your court. I don't really have problems with Zoom on a general basis.
Okay.
I don't know. I will have somebody look at it, but
Okay. All righty. Well, we'll see you then. Okay, guys.
all right.
Thank you, Your Honor. Okay, well.
Our next hearing is Milan Properties versus Aceron. Are both sides here on that?
Yes, Your Honor.
Yes, Your Honor.
All right. All right, are we ready to proceed? Let's go on the record on DC 23-13079, Milan Properties versus Aceron. Counsel, make your appearance.
Jim Eppright for plaintiff.
Austin Hartline on behalf of the defendant, Christina Acerone.
I noticed there was some briefing filed today. Is that responsive to this motion or to something else?
Yes, Your Honor, that's defendant's response to plaintiff's motion.
Okay, you're supposed to file it 3 days in advance.
My apologies, Your Honor. I supplied it to opposing counsel late last Friday.
Okay.
Your Honor, I filed a supplement to the motion, which included defendant's second amended disclosures, which eliminates a few of the issues raised by my motion.
Raised by their motion?
By my motion, plaintiff's motion.
Okay. All right, let's proceed.
All right, good evening to all. Please note that some of the things about which I complained in the motion were based on defendant's production at the time the motion was filed. Some have been dispensed with, but several remain. During the certificate of conference, defendant's counsel did not agree to anything although he did state repeatedly he had had trouble getting his clients to provide documents. We've all been there, I think. Apparently, my filing this motion got his clients to provide some, but far from all of the documents that were requested in the request for production, some of which absolutely exist. And although I will address it later, awarding plaintiff its expenses might prompt greater cooperation from defendants. If not, I believe it's one's obligation to withdraw from a case if the client will not allow the attorney to comply with the rules. So, as I said, this morning I filed a supplemental motion, which included defendant's second amended disclosures. Even with this much improved disclosure or set of disclosures, defendants failed to state a factual basis for any of the defenses contained in their amended answer, which were impossibility or impracticability of performance, and defendants didn't state how that happened and for how long. I do have the orders that Governor Abbott issued, but they certainly don't cover the entire period of the pertinent period of the lease, just a few months. I believe that should be defendant should say how and for how long performance was made impossible or impractical. Also, there's an affirmative defense of failure to mitigate. The lease premises were relet twice, and plaintiff disclosed both leases and dozens of emails between its broker and potential tenants. And I believe defendant should state what plaintiff failed to do that it should have to mitigate its damages. Next was the issue of defendant Azeron's objection to one of the requests for production. That request.
All right, so let's do this. Let's go through one at a time so I can rule on these separately. So what's the request for production that he still hasn't responded to?
The request for production are the disclosures that are insufficient.
All right, so which disclosure do you say is still not sufficient?
Regarding defenses.
Okay. And that's attached here, I guess.
It's on the supplemental motion.
Okay. Go ahead and screen share that.
I'm sorry, I haven't set that up to do that.
He said he would.
I can, however, it's saying host disabled.
No, it's enabled now.
Okay. Can everybody see that?
So the first objection is to the impossibility or impracticability of performance.
It's not stating the factual basis.
Okay. I think it's fine. That one's overruled. What else do you have?
And the next one is the failure to mitigate.
Oh, I'll reshare. My apologies.
Oh, that one's fine too. All right. What else do we have? Which request for production?
This is request for production number 1. It asks for financial and tax documents because it's plaintiff's inclination at this point that the business was failing before the governmental restrictions went into effect. And what was not provided were accounting records and plaintiffs interested in general ledger and the cash receipts and disbursements journal for all periods. Also, the bank statements, none were provided, and brokerage account statements, none were provided. Of course, if none exist, then they can state they haven't been identified.
So clearly that, so when was this, so you're asking from the date of inception, basically all of their financial records. When was Perfect SK Medical Management created?
Late in 2018.
Okay, so it's relatively new. All right.
Yes.
And
It no longer exists, Your Honor. It was wound up and no longer exists on the Secretary of State.
okay.
I think that was in 2021, potentially 2022. And which request are we looking at right now?
Request for production number 1.
Do I need to pull it up?
No, I haven't. I think I'll share a screen and I'm pretty sure this is what he's talking about.
Do you have the supplemented version?
I don't know. This is what I have.
Yeah, that's not the supplemented version. I supplied it late last week on Friday to opposing counsel in every effort to try and avoid expenditure time here today. I can share my.
Yeah, why don't you share screen it?
Okay.
What I said, I took that into account. We have the federal income tax returns. We have adequate financial statements. It's just accounting records, banking statements, and brokerage account statements, none of which were supplied.
And Your Honor, if I may respond.
Sure. You're not share screening, just so you know.
Oh, let's see here. I thought
I
mine's.
think I need to stop sharing. Now, is that yours?
Oh, okay. I think we may be seeing mine now. I think yours might have been overlapping mine.
Yeah. Okay. Let me see. So you provide the tax returns for 2018, 19, and 20. And what did you provide exactly for accounting records?
I tried to summarize it. Let's see here. There were summaries that were provided and shared with opposing counsel. I need to preface my response with the fact that almost all of the records that I am supplying in response to this request are coming from the co-defendant, Rodell Aguirre. He was the business partner to Christina Acerone. We do represent both of them in this case. And he was the records custodian and general keeper of all documents, come to find out through this discovery process. They've made a joint effort, of course, to try and comply with plaintiff's request. All of that to say is some of these requests may have been better off made as to Mr. Aguirre specifically. However, we're trying to preserve additional litigation efforts by responding with the documents Mr. Aguirre has produced to assist here.
I would like to mention that Dr. Acerone was a managing director of the now defunct entity, and obviously has the right to all records of it.
All right. So you provided summaries, but not the underlying documents that created the summary. Is that right, Mr. Hartline?
Your Honor, I'd have to double check. There are financial documents there that are not summaries. They are profit and loss statements, and I'm sorry, I'm recalling from memory. I can pull them up if needed. But I do believe they respond to the request, and I'm not entirely sure how they relate to the breach of contract or what the burden of proof is as far as what plaintiff is trying to prove as for their causes of action. But I believe what we have supplied is sufficient for the request as they are asking. And as I mentioned, I'm supplementing as I get additional documents from my clients. And that's not a lot.
So let me just kind of roll to the extent that you provided summaries, because you had said earlier you provided summaries, then you need to provide the underlying documents if they exist.
Okay, and I'll make sure to notate a future response if such documents do not exist.
Yes.
Your Honor, the only documents at this point that I really want are under B, general ledgers and cash receipts and disbursement journals. Under D, the bank statements, and if there's a brokerage account statement or any statements, then those as well, or at least a statement that complies with the rule.
All right. So go ahead and again, any documents that support any summaries that have produced, those are to be produced. What else do we have? Was that it?
No, Your Honor, I'm sorry, I'm just making a note. Next is a request for production number 2, which asks about loans, and the entity received a Paycheck Protection Program loan, which was forgiven, but no documents were produced in connection with that. Also, I asked for loans to or from others, and there were no documents to that effect, except on the minimal financial documents reflected the tenant company had loans for equipment totaling $379,000, although no loan documents were provided. So I would ask for the application, any other documents related.
Why is that relevant? I don't quite understand why that would be relevant.
Because
all discoverable in this case. This is a lease dispute, right?
They're alleging defensive impossibility or impracticability of performance. And if they get Paycheck Protection Program loans or loans from others, then obviously they would have capital to continue with the business. If there were loans to
okay, I get it, Mr. Cartland.
And Your Honor, I've spoken with my clients about these PPE loans, as plaintiff alleges. They do not tell me that they received these loans and don't have any documents to support such a loan application. If they did, that would have provided them to me by now. I think there's some inferences being made as far as some of the documents that we've produced that lead opposing counsel to potentially believe that there were some sort of PPE loans, but my clients deny the fact that they ever applied for them.
The government website shows there was a loan. And in fact,
I don't have any documents to produce as far as a PPE loan goes. And
all right, so the objection's overruled. So the objection's overruled. You're to produce it if it exists. All right, what else do we have?
A request for production number 4. There were there was about $13,000 worth of equipment beyond the equipment that was collateral for a loan. And no documents were produced that reveal how those assets were disposed of. There were $50,000 in loans indicated from members of the LLC. There were no documents that indicated if those loans were repaid or not.
And after talking to my clients, Your Honor, almost everything they had, and it may be everything that they had, I just don't want to overspeak, was leveraged or financed. There wasn't a ton of assets or anything. I mean, there may have been some product and things in some boxes that wouldn't amount to very much given the type of work that they did. But as far as my conversations about discovery have gone, there's not, the majority of any equipment was leveraged and had to be returned to the lender.
The $13,000 in equipment was not collateral for the $379,000 equipment loan, according to the financial documents that were provided.
The objections overruled you to produce what exists.
And I would just ask that the statement that after diligent search, no such documents exist, so that I know they don't.
Fine. That's fine.
And I'll have to supplement with that sort of response, I think, in any of these that are being overruled.
All right, why don't we, have you guys conferred on all of this?
Yes, we have, Your Honor.
Yes, Your Honor, and I'm going to go back to Dr. Asarone is not the primary records custodian. She doesn't have access to almost all of the documents, or she doesn't have them in her own file system. We're having to rely on Mr. Aguirre to respond to almost all of this, who has not been provided with any request for production in the case.
Again, she is the managing director of the LLC and has a right to those documents. Next, I want to cover the request for extension of plaintiff's discovery period to not include defendant's discovery period, and also a few comments about why plaintiff should be awarded its attorney's fees.
Okay, first off, I'm not going to award any attorney's fees at this point. And so what was the last thing? An extension of time to do what?
A plaintiff's discovery period. This discovery period ends May 14th. I was waiting to get some of these documents before drafting some interrogatories and requests for admissions. Clearly, with the limitation on requests for admissions and interrogatories, I didn't want to shoot in the dark, but I only received most of these documents. I think it was April 24th and April 25th, which if I had...
Mr. Hartline, we're going to extend the discovery period. So what do you guys want to extend it to?
Your Honor, if I may respond to that, just to add, we've been agreeable to extending the discovery period for quite some time and have tried to come up with mutual agreements as far as that goes, even removing it to level 2 discovery if needed. I would be agreeable to 90 days. It doesn't make a big difference to us. We'll do everything we can to comply to discovery responses. I would ask, in addition to that there either be an agreed scheduling order due within 14 days time to avoid having to come back on any discovery issues as to timing.
I'll go ahead and extend the discovery period. I'm going to instruct the parties to go ahead and prepare an agreed scheduling order to try to clarify all of these issues. And Mr. Upright, go ahead and prepare an order on all of this, share it with Mr. Hartline. It needs to say at the beginning of the order that this was heard on May 6th on Zoom, and provide that to Mr. Hartline. And then give me that order by this Friday. Mr. Hartline, go ahead and share it with Mr. Hartline before you submit it. Do you guys have any questions?
No, Your Honor. Thank you very much.
Yes, Your Honor. As far as the scheduling order, when did you say that you wanted?
I'd like that within the next 2 weeks.
Okay. And is there a deadline for mediation on there? I'm not sure if you're.
Usually I do 30 days before trial, but if you want to do earlier, that's fine with me.
I thought you said
Sooner, just to give the parties an opportunity. I would say in 60 days even.
I thought you said you wanted the scheduling order by this Friday. What, did I misunderstand?
No, I wanted a copy of this order, the order that reflects my rulings in this hearing.
Yes, Your Honor, and I'm supposed to draft that?
Yes. And then you share that with Mr. Hartline and make sure it says at the beginning of the order that this was heard on May 6th, 2024 over Zoom instead of on this date. Share it with Mr. Hartline. Hopefully Mr. Hartline will sign off as the form, and then submit that to the court by this Friday. You have 2 weeks to get the new agreed scheduling order in.
I understand.
If you can't agree to it, then feel free to set that for hearing.
And is there a mediation deadline? That's not the third. We do 60 days for a first attempt at mediation on the agreed scheduling order, or do we need to work that out amongst ourselves?
You guys, my normal rule is 30 days before trial, but if you want to do something different, that's fine with me. It's not a rule, my normal policy, I guess.
Okay, understood.
But if you want to do it earlier, I'm totally okay with it. You guys need to reach an agreement on it. All right, guys?
Yes, Your Honor. Thank you.
Thank you, Your
Give me
Honor.
an order on that. All righty. You guys have a great rest of your day.
Thank you.
Are both sides here on Cantu versus Smith?
Yes, Judge.
Both sides are here?
Yeah, Mr. Dunlop, I see his name in one of the boxes. And he represents the defendant, or the plaintiff, excuse me.
All right. Tony, are you ready to go on the record?
Yes, Judge.
Plaintiff's counsel announce the name of the case and the cause number. Plaintiff's counsel announce the name of the case and the cause number, please.
Judge, I represent the defendants. I'm happy to do it if you would prefer.
Is the plaintiff's attorney not here?
He is. He's on video. It's Mr. Dunlop, but he may not have audio on.
All right, go ahead and announce the name of the case and the cause number.
Judge, this is Laura Cantu versus Kyle Smith et al. Cause number DC 2210595.
All right, let's proceed.
Thank you, Judge. May I share my screen?
Sure.
We're here today on 3 Rule 248 motions that we filed pre-trial. We were set for trial last month and we're not able to go. We were third on the docket, but another case ahead of us did proceed. These 248 motions are, excuse me, just to orient the court to this case. This is essentially an employment discrimination, wrongful termination type case. Laura Cantu was employed as an executive within the Holy Savior Hospice companies. The court has, and she was terminated. Excuse me, she was not terminated. There's a dispute about whether she was terminated or resigned following an altercation and concerns about her employment status. Because these are 248 motions, we're not going to focus very much on the facts of the case and focus instead on some legal issues that we'd like determined.
Haven't I ruled on all this stuff before?
Yeah,
Why
yes,
are we doing this again?
Yes, you have, Judge, and I apologize. I was in front of Judge Moncrief. if I may, I have an objection to you hearing these motions. Basically, Rule 248 says that when a jury has been demanded, questions of the law, motions, exceptions to pleadings, and other unresolved pending matters shall, as far as practicable, be heard and determined by the court. All three of these motions are really just repackaged motions to reconsider the MSJs that you have already addressed these issues. So this is really, you heard an MSJ, you granted it in part, denied it in part. You heard a second MSJ, you denied it in its entirety because it was a motion to reconsider. And these Rule 248 hearings motions are really just another attempt at, hey, Judge, please grant us the motions for summary judgment that you've already ruled on. There are no new unresolved pending issues being addressed by any of these motions. So I'm asking the court to just not even consider them.
Judge, counsel has not correctly stated our motions. These motions, there are three of them. Only one of them raises an issue that the court has previously considered. One of them simply asks the court to determine whether, and I'll move, this slide here was just summarizing the status of the case, that there are two live substantive claims, and there are some derivative claims based on one of them. And those are the only issues left in the case. The 248 motions focus on several issues. Issue 4.
I've already ruled on all this stuff. You may disagree with me. I may be wrong. The Court of Appeals may agree with you. I ruled on this stuff. This has been done.
Judge, respectfully, the issue of whether a private cause of action is available under Human Resources Code, section 48.257, was not raised in our summary judgment motion, and it's not been ruled on by the court. The question of whether the plaintiff has failed to exhaust her administrative remedies following her unsuccessful petition before the Texas Workforce Commission, and whether she has forfeited her common law claims as a result of pursuing that avenue, have not been raised in any summary judgment motion and have not been ruled on by the court.
Do you agree
we would
with that,
ask the
Mr.
court
Dunlop?
to issue a ruling on at least those issues in this hearing.
Mr. Dunlop, have I already ruled on this?
Yes, Your Honor. You indulged the motions for summary judgment, both of them. You allowed Mr. Gillette to make the argument over my objection on the second motion for summary judgment. They went into these very issues. And, Your Honor, this is just a please reconsider. These are basically motions to reconsider.
Judge, that's not accurate.
That's why the issues sound familiar to you, Your Honor. That's why.
Yeah, they sound not just familiar. Okay. I'm not going to. Yeah.
Okay. If I understand the court correctly, the court is holding that a private cause of action is available under section 48.257. I
have ruled on all of this before. I'm going to punt this to the day of trial. So that is my ruling.
Okay. Well, very well.
Thank you, Judge.
All righty, guys. You have a great rest of your day. And
Thank
please
you, and I
stop bringing
apologize
the same
about
motion over and over again. You guys have a great rest of your day, okay?
Thank you, Judge.
All right, what's our next? What do we have next? We have a minor prove-up. I'm sorry, Odyssey is working terribly. Rhonda, do you know what our next thing is? Okay, here it is. All right. Let's go on the record on DC 242568, Rose versus Walmart Stores of Texas. Counsel, make your appearances.
Good afternoon, Your Honor. Fatima Hassan Salam for the plaintiff. Unfortunately, her video feed just went down and she's not on the line. Earlier on, and now she can't get back on.
What? Is she on here? We just can't see her.
Let the judge know. So she can't get into Zoom.
Yeah, I told her she could probably copy and paste it. I'm not sure what she's doing, but they were asking for a dial-in number or something.
Okay. Yes, I can give her that. Just.
And on behalf of defendant Walmart Stores Texas LLC, Hunter Olson, Your Honor.
Fabiola Segovia, guardian ad litem for minor MR.
And there's a Sheila Golden here. That's not your client?
No, sir, she's not.
Okay. There's a Michael Mohammed signing on. Is that?
I am with the Michael Mohammed.
Is that for the 415? That's for the 415 hearing, so a different hearing. Okay, so your client's trying to sign in?
Yes, Your Honor, she was on earlier and I don't know what went wrong.
She's dialing in now.
Thank you, Ms. Pinson.
Is she dialing into you, Rhonda, or is she dialing into
Into Zoom.
Okay.
Be just a few minutes.
All right, let me. Okay, while we're doing this, why don't we just talk about what is the total settlement on this and what's the breakdown? We'll do this off the record.
Your Honor, the total settlement is $25,000.
Okay. For the minor?
For the minor is getting $10,091.01.
Okay. And what are the attorney's fees?
The attorney's fees are $8,333.
Okay. All righty.
Just set it on the screen.
Your call has been forwarded to voicemail.
Well, what do we want to do here?
Do you want us to wait while you do the next hearing, Your Honor? I'm not sure Ms. Pinson's trying to get online.
Is it Sammy Golden Gammy? Is that her?
No, her name is Zubaida Rizan.
Okay, we had someone just join.
Hello?
Ms. Rizan?
Yes, this is Zubaida.
That's her, Your Honor.
Okay, while we can, why don't we go ahead and get started. Go ahead and call your first witness.
My first witness is Zubaida Rizai.
Ma'am, please raise your right hand. Are you raising your right hand? I can't see you. Ma'am, please raise your right hand.
Are you talking about me? I'm on the phone, so I can't raise my hand.
You can
Okay,
raise your hand, listen to the judge.
You need to raise your hand, ma'am, please.
Okay.
Are you raising your right hand?
Yes.
Right. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
All right, you may proceed, Ms. Salam.
Thank you, Your Honor. Please state your full name for the record. Ms. Rizai.
Go ahead.
Zubaida Rizai.
Ms. Rizai, did you file suit against the defendant Walmart store as the next friend of Mirab Rizai for an injury she sustained on June the 9th, 2022?
Yes, ma'am.
Would you state your relationship to Mirab, please?
I'm Mirab's mom.
And what is Mirab's date of birth?
It's May 16, 2013.
How old is she today?
She is 10, but she's going to be 11 on May 16 in 2 weeks, I guess.
Could you briefly tell the court how your daughter was injured?
They were moving the pallet without paying attention, so they didn't see her and hit her with the pallet, and something were insert it inside, and the Walmart owner called the ambulance, and she was taken to the ambulance. To the emergency room.
And did she receive, which emergency room did she go to?
Medical City, Dallas Medical City.
And did she receive treatment at any other medical facility?
No.
Was she taken to Advanced Dallas Hospital to see a doctor?
Oh, yes.
Is she having ongoing problems or any pain in her foot right now?
No.
You understand you're here today to settle the case against Walmart, is that correct?
Yes, ma'am.
And you understand that you're settling the case for $25,000.
Yep.
And out of that $25,000, the Dallas Fire Department, the emergency room physician, the hospital, and Medicaid will be repaid in addition to attorney fees.
Yes.
Do you understand?
I do.
And do you understand that your daughter will only receive $10,091.01 out of the settlement?
Yes, I understand.
Do you understand that you have until she turns 18 to settle this case?
Yes.
Do you understand that you have a right to a jury trial?
Yes.
And you understand that the jury could award you more or less or the same amount?
Yes, I understand.
And by accepting the settlement today, you're waiving your daughter's right to a jury trial?
Yes.
And that if Mirab has any problems with her foot after this, Walmart will not be responsible for any of the bills or treatment?
No.
Have you had the opportunity to meet with Ms. Segovia, the court-appointed attorney, the guardian ad litem?
I spoke to her on the phone, but I haven't met her in person.
Have you discussed the case with her, and has she answered all your questions?
Yes, she did.
Do you think it's in the best interest of your child to accept the $25,000 and settle this case?
Yes.
Based on all we've set forth on the record today, are you asking the court to accept this settlement?
Yes.
Thank you, Your Honor. I pass the witness.
All right. Mr. Ralston, do you have any questions?
Just the few, Your Honor. Ms. Urzea, have you been able to review the final release settlement and indemnity agreement that sets forth the amounts for your daughter?
Yes, sir.
Okay. And you've accepted those amounts that have been reflected in that settlement agreement?
Yes.
Okay. And do you understand that the settlement amounts for Urzea will be invested in an annuity for the benefit of Ms. Urzea, your daughter?
Yes, I do understand.
Okay. And do you understand that you have no obligation to settle this case at this time, that you have the right to proceed further with the jury trial if you choosing to?
Yes.
Okay. And do you understand that if the judge approves this settlement today, neither you or anyone else can come into court again to claim damages related to the incident?
Yes.
Okay. And do you understand that this is all the money that you will receive from Walmart Stores Texas LLC or its insurers for this accident and the resulting injuries and damages?
Yep, I understand.
Okay, great. Thank you, Your Honor. That's all the questions I have. Pass the witness.
Good afternoon. Is it Zubaida? Zubaida?
Yes, ma'am.
My name is Fabiola Segovia. You and I have spoken multiple times about Mirab's case. Is that correct?
Yes, ma'am, you did.
All right. So your attorney has covered most of the questions regarding the incident. Now, let's talk about the her current state of her foot. During our conversation, you indicated that Mirab does not have any pending medical appointments to treat the injuries sustained in this incident. Is that correct?
Yes, ma'am.
So she's completely done with her treatment at this time. Is that right?
Yep, she's done.
Okay. At the time of the incident, Medicaid paid for the majority of her medical bills, including the Medical City and Parkland. Is that correct?
Yep, I didn't pay anything out of pocket. So I don't know if it's the Medicaid has paid or it's unpaid. It's still, I don't know.
Okay. Well, Medicaid will be reimbursed from this settlement. They have retained a lien, but they will be reimbursed for what they have paid. In addition to other bills incurred at Advanced Dallas Hospital, where she was seen, and also they took some imaging of her injury. Do you have any bills arriving at your home?
No, all I sent to Miss Fatma.
All right. Okay, so in our time working on this matter, I provided you with 4 different annuity options, and you have chosen plan number 1, which is a guaranteed lump sum at age 18. The lump sum will be paid on May 16th, 2031, when Mirab turns 18. And the first payment will be $6,416, and 30 days later, she will receive the second payment of $6,416 for a total of $12,832. Is that correct?
Yes.
All right. You picked this option for her. Is that correct?
Yes, ma'am.
All right. And we have discussed the importance of you keeping your address up to date with this company. It's Pacific Life. It is very important that you keep your address up to date with them to continue to receive all of their paperwork. And we discussed that, correct?
Well, I didn't choose that one. You told me to go to update my address every year in the code, and I didn't accept that one.
No, you don't have to update your address with the court. You have to make sure your address is updated with the annuity company if you were to move, so that they can get a hold of you continually.
Okay, all right. If you send me the contact info, then I will be updating my address, but I didn't know about this.
Yes, your attorney will provide you all of copies of all of this paperwork and the address and contact information for Pacific Life Annuity.
All right.
Miss Razai, this is a tax rate, a tax-free interest rate of 6.43. We discussed that this was going to earn interest, but you chose this as best interest for Mirab. Is that correct?
Yes, ma'am.
All right. Ms. Razai, are you asking the court to approve this settlement and annuity plan because you believe that this is in the best interest of Mirab?
Yes.
Okay, and you understand that these funds that she will have access to when she turns 18 will be for her use and her use only, correct?
Yes, ma'am.
All right, I'll pass the witness.
All right.
Okay.
Ma'am, do you have any questions for me?
No, sir. I'm sorry for being late.
It's okay. I know sometimes Zoom is difficult. So I guess I had a question for Ms. Segovia. So the annuity is going to be paid out in over 2 months, like right back to back. Is that was intentional?
That's correct, Your Honor. Ms. Razai wanted the annuity to be paid out as soon as possible, and the annuity company could not do one lump sum payment, but they could do two back to back.
Okay. And she felt this was better than registry of the court.
Yes, she mentioned that she did not want to go to the court or just deal with, if this was going to be an easier process, that's what she chose.
Okay. Is there a recommendation of the guardian ad litem?
Yes, Your Honor. Based on all of the information provided in my investigation into the treatment and that there's no permanent disability with her foot, I do believe that the offer of $25,000 extended by the defendant to MR is reasonable to compensate MR for the injuries she sustained at Walmart. I believe that the 6.43% interest is a great interest rate at this time. And it is my opinion that the settlement and annuity plan chosen by the mother are both in the best interest of Mirab. So I would respectfully request that the court approve the settlement at this time. My guardian ad litem fee in this matter is $2,025 for 8.1 hours of work. As far as I know, defense counsel had no objections.
No objections, Your Honor.
Okay, great. All right. The court will go ahead and grant the dismissal as requested by the parties and approve the settlement. Thank you so much, Ms. Segovia, for your service on this, and you have a great rest of your day, okay?
Thank you, Your Honor.
All right, thank you, guys.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Ms. Razai. Bye.
Bye. Thank you, Ms. Hartman.
Okay. All right, do we have everyone here for the default?
Yes, Judge, we're all here.
Okay. All righty. Can you go ahead, Tony? Are you ready?
Yes, Judge.
All right, let's go ahead and go on the record. Sir, if you can go ahead and announce the name of the case and the cause number.
Okay, the name of the case is Calvin Golden and Sheila Golden versus Ridgeline General Contractors LLC and Lance Moore.
All right, let's proceed.
The plaintiffs are present, and I'm Michael Muhammad, counsel for the plaintiffs.
Okay. You may proceed.
Okay, first we'd ask the court to take notice that citation was indeed served and returned. It has been on file for the requisite amount of time, 10 days, that it's required to be on file.
Okay.
And we'll call Calvin Golden.
All right, sir, please raise your right hand. Do you swear or affirm the testimony you're about to give show the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, let's proceed.
Okay, state your full name.
Calvin Golden.
And you're the plaintiff in this case?
Correct.
And your wife is also a plaintiff in this case?
Yes,
And is that your wife sitting there with you?
that is correct.
Sheila Golden? Okay,
Yes.
you entered into a contract. You've seen the petition filed in this matter, correct? The
Yes,
original, and the facts that stated in that petition are true?
yes,
You and your wife entered into a contract for the remodeling of your home with Ridgeline General Contractors and Lance Moore, is that correct?
yes.
And what was the original contract price?
The original price was $123,165.
And then was there any other costs associated with it?
There was
Were
a
there any
change order for $26,000.
And how much did you pay to Ridgeline General Contractors?
Total, $149,165.
Okay. Did Ridgeline General Contractors?
Say the number again, please.
Total $149,165.
Thank you.
Okay, Calvin, that was the total contract price. How
Right.
much did you actually pay? How much of your money went out to, was it $123,165?
Right, $123,165, correct.
Okay. Now, you had to hire a replacement contractor to complete the job.
Yes, we did.
The replacement contractor was hired to complete or repair the faulty work that had been performed and also to complete the job. Is that right?
Yes, sir, that's correct.
And how much did you have to pay to the replacement contractor?
$250,000.
Did this include costs to make necessary repairs to the construction defects?
Yes,
And was this cost reasonable and necessary to complete the project in excess of the contract price plus the change orders?
yes,
Okay, the funds that you paid out to the defendant again was $126,134.
yes, sir, it is.
Okay, so the total you're seeking in damages are the excess contract costs and what you've paid to Ridgeline, which is $226,970. Is that correct?
Correct, yes, sir.
Right,
Did
say
you
that
have-
number, say that number again, sir. 226,000 what?
970.
Right, the amount you include on your default judgment is 250,000, is that correct? Or should it be this 226,970?
He has more elements of damages that we're
Okay,
going to
all
go.
right, go ahead then.
Okay, did you also have to obtain temporary housing?
Yes, sir.
During the repair period? And how much have you paid for temporary housing?
$25,000.
And that's out of pocket today?
Yes, it is today.
So your total damages are $251,970. Is that right?
That's correct.
Now, let me ask you something here. Now, I informed you that we filed this action as an expedited action, and the cap on damages for an expedited action is $250,000. I also informed you that we could refile or we could amend the pleadings if you wanted to obtain your additional damages. And you stated to me you wanted to go forward. Is that right?
Yes, it is.
Okay. Did you incur any attorney's fees?
Attorney fees, yes.
Okay. And how much have you paid in attorney's fees?
To date, $11,639.
Okay. And you also incurred court costs and expenses?
Yes.
And how much were your court costs and expenses?
$510.12.
Was it because of Ridgeline General Contractors and Lance Moore's failure to perform in breach of the contract that caused you to incur these damages?
Yes.
And was it foreseeable to Lance Moore and Ridgeline General Contractors that you would incur damages if they didn't perform?
Yes, it was foreseeable.
Okay. So you're asking the judge to award $250,000 in damages plus attorney's fees of $11,639 and $510.12 in court costs and expenses.
Yes, correct.
We don't have any other questions, Judge, and at this time we would request the court enter a default judgment holding Ridgeline and Lance Moore jointly and severally liable and award the requested damages.
Okay. So let me just make one quick comment before I make a final ruling. Did you know that the other side sent a letter into the court back on April 15th? Did they send you a copy?
They did not send me a copy, Judge, and I was going to mention that to you. We learned this afternoon, actually, that there is an answer there.
Yeah, so what they've filed is kind of unusual. It's basically trying to argue the case. But then
we did not receive that. I only learned about an hour ago that was there.
So it's a close call whether or not this is actually an answer, because he says at the end, it says RGC has meeting records, photo documentation, text message correspondence, and email correspondence, witness, and other documentation. RGC will present if the plaintiff refuses to dismiss the suit. In return, RGC will file in countersuit for all original contract fees, time and effort resolution, and attorney's fees. So it isn't really, I mean, I'm pretty liberal about what I interpret as an answer. This seems to say he will file an answer unless you, so I don't know. I mean, do you still want to go forward with this default, or do you want to?
Yes, I still want to go forward. If he appeals it and we have to start again, we will, but we haven't been able to reach him or find him, etc. So we'd like to go forward.
Okay.
And we'd also note that it doesn't have a signature on it. It looks like it's printed, and it doesn't have a address, etc., or any contact information on it.
Yeah, no, I agree. It's pretty problematic. All right, well, we'll see how this goes. I just want to make sure you saw that it was filed back on April 15th. I'll go ahead and grant default judgment because I don't think that's an answer. It's kind of a close call, although the clerk's designated as an answer. We'll see how this goes. I wish you the best of luck, and we will go from here. You guys have a great rest of your day, okay?
Thank you, Judge.
Thank you.
You can sign off now, Kelvin.
Okay.
Thank you, guys. Thank you, Mr. Muhammad.
Thank you, Judge.
All right. Any news on our trials for tomorrow? Do we know anything? Have we heard anything?